Just a couple of things before we get started. Angela, do you want to just show yourself just a brief second just to introduce yourself to everybody?
Yes, good morning, everyone. I'm excited to be here. I'll be chairing this panel with Dr. Vinti. Dr. Vinti will introduce the speakers and I will handle the question and answer session.
Okay, great. Thank you, Angela. Just a few housekeeping rules, guys, for everybody. Please make sure that your video is switched off if you're not presenting, and also that you mute your audios so that we can allow the speakers to speak without any interruptions. And if you've got any questions, please post them on the chat box, or you get an opportunity at least in the last 20 minutes to ask your questions directly. So please feel free to put your questions in the chat box. We'll collate them from there. And also, like I said, you can also ask the questions directly. Without much further ado, I think everybody obviously has got the program in front of you. Just by way of introduction, the name of this session is Local Government and the Environmental Right. We have a great crew of speakers. The first presentation is going to be done by Ms. Johandri Wright, Dr. Felix Dube, and Professor Anél to Plessis from the South African Research Chair in Cities, Law and Environmental Sustainability at Northwest University. And the title of their presentation is going to be In Search of Solutions for Urban Sustainability, Judicial Enforcement of Provincial Interventions in Local Government. And then thereafter, we're going to have Prof. Anél to Plessis. Again, she's going to be presenting on when the legal objectives of sound financial management, environmental justice, and spatial transformation collide, the case of South African cities. So the speakers each have 20 minutes to speak, and then in the last 20 minutes, we'll have open the floor for a discussion. And I think the whole issue of local government is particularly a topical issue right now. We've seen recent case law coming out of the Northwest High Court, where a community was essentially given control to address issues of sewage spill into the water in the area that they live in, if the municipality had not done its job. So we know that the system of local government in South Africa particularly has collapsed, and many a time people have called upon national government to intervene, but to no avail. So apart from malfeasance and corruption, we also have recent instances like now where, as you have seen that in the Northwest High Court, I think it's in the Hetland River case, where a community there's an option that they may have to take over the fixing of pollution in the area from a sewage spill. So there's a lot of problems that are happening with local government, and I think these discussions that are going to be presented today will be particularly topical for the issue. Now, everyone's not here to listen to me, we're here to listen to the speakers. So I will call upon Ms. Johandri Wright, Dr. Felix Dube, and Professor Anél du Plessis to take over and do the first presentation. Are you guys ready to take over?
Yes, we are. Thank you.
Thank you. Please go ahead. You have 20 minutes. I will let you guys know when you have 5 minutes left.
Is it in presenter mode?
I think you still have to put it in present mode. If you just go to the bottom of your screen, there should be an opportunity. Just right below on the right corner of your screen, there's a desktop. Yeah, there you go. Thank you.
Okay, thank you so much. So recently, many municipalities have become notorious for incurring crippling debts and for their inability to afford and sustainably deliver basic services such as water and electricity. This led to the headlines we so often see, which refer to the collapse of local governance in South Africa. In addition, the Auditor General reports for both 2020 and 2021 have painted a bleak picture of municipal service delivery and questioned the financial viability and overall functionality of municipalities. National Treasury reports also showed that in the third quarter for 2020, that 80.5% of all municipalities face serious financial problems, and that 49% of municipalities find themselves in financial crises. These are just a few of the many examples of the dire state of local governance in South Africa, and many argue that financial problems are at the very heart of service delivery problems. It is for these financial problems that led to some municipalities, such as the Makana local municipality, to halt service delivery altogether for a long period of time, which brought about many difficulties for residents. One can thus argue that the financial collapse of municipalities negatively impact the sustainability in South African towns and cities by, amongst other things, not being able to provide municipal services, the effects of which can be felt in every dimension of sustainability. On the economic front, a lack of service delivery due to the financial collapse discourages external investment. Businesses also cannot function properly without services such as electricity, clean water, and inaccessible roads. On the social dimension of sustainability, it could be said that a lack of service delivery halts the development of communities. And on the environmental dimension of sustainability, a lack of service delivery, such as improper waste disposal of solid or water waste, have devastating effects on the environment. For example, the sewage works of Mfuleni municipality that burst and had waste running into the Vaal River. An argument can be made that residents of South Africa have a reasonable expectation for good local governance. The interpretation and execution of good governance are context dependent, and communities are likely to respond differently when the expectations are not met. In the South African context, the heartbeat of good local governance is public authorities' respect for and protection of the basic human rights of local communities. All organs of state, including municipalities, must fulfill, promote, respect, and protect all the rights in the Bill of Rights. For example, all residents must be treated with dignity. Governance should facilitate public participation, which includes peaceful protests. The Constitution further establishes the values, relations, and functions which determine how municipalities should govern. Some of these include decentralizing and establishing legal and institutional frameworks for accountability, transparency, and public participation. Municipalities should furthermore provide sustainable public services and to develop the capacity for the effective and efficient management of resources and the provision of quality services. Municipalities must therefore prioritize the provision of basic services and provide the economic and social development of communities. For this, optimal utilization is required for social and economic development and to promote a safe and healthy environment, as well as other constitutionally entrenched rights. One can thus see that the constitutional imperatives are critical pillars for the social transformation project in South Africa. National laws and policies give more substantive content to this framework for good governance as entrenched in the Constitution. The Systems Act affirms Section 195 of the Constitution's principles and describes undesirable conduct and also state how public officials should conduct themselves. The Municipal Financial Management Act provides standards of behavior relating to the management of municipal finances and how to make financial decisions. And lastly, the white papers and the Back to Basics policy supplement these standards of behavior for municipal officials as described in the Systems Act. I now hand over to Dr. Dube.
Thank you, Johandri, and greetings to everyone. I will speak about provincial interventions in failing local government with a specific focus on the applicable constitutional and legislative framework for such interventions. But I should first highlight that the Constitution grants municipalities autonomy to run their own affairs without undue interference from their provincial and national counterparts. The Constitution even reserves certain functional areas for local government. This is in line with what one could call our quasi-federalist approach to governance. However, municipalities are not always in a position to exercise their legislative and executive powers. This is due to human resource constraints and the lack of expertise in municipalities. As such, municipalities look forward to the provincial and national governments for assistance. However, there are instances when municipalities fail to provide basic services as required by the Constitution. When they collapse, their communities are severely affected. And this collapse could entail the failure to provide water, electricity, solid waste removal, and other basic services. As I will demonstrate with the Makana and Emalahleni municipalities in my presentation. Fortunately, the Constitution envisages scenarios in which municipalities fail and collapse, necessitating provincial interventions. Provincial and national interventions were never designed to infringe on the constitutional autonomy of municipalities or to become the go form of local government support. As such, interventions should, in principle, not interfere with the municipality's autonomy to regulate the affairs of its community. Notwithstanding that the Constitution grants municipalities protection from unnecessary provincial and national interference, there is a tacit acknowledgement that at times the problems that affect municipalities may be beyond their competence and capacity. This makes it necessary for provincial and national governments to intervene. The supervisory powers of provincial and national governments are divided into 4 categories: monitoring, support, regulation, and intervention. In this presentation, I'm interested in the last one, interventions. Section 39 of the Constitution and Section 137 of the Municipal Finance Management Act regulate discretionary provincial interventions in local government. They prescribe the circumstances in which such interventions could occur and the procedure for such interventions. The provisions stipulate that when a municipality fails or is incapable of providing basic services to its community, the national and provincial governments may intervene in such a municipality. A provincial executive may intervene in a municipality, in the affairs of a municipality, and assume responsibility for a municipal obligation which the municipality is unable to fill. This is a preemptive step to prevent more radical forms of provincial intervention, such as the dissolution of the municipal councils. However, such interventions always come after the fact, in that the municipalities would have already been suffering and the governance in that municipality would be collapsing, making it very difficult for the communities in those municipalities to survive, as I will show with the Makana situation, to which I now turn to. So what is Makana? The Makana municipality is a municipality that governs the town of Makanda, which is formerly Grahamstown, and surrounding areas in the Eastern Cape province of South Africa. In 2020, the municipality faced a multitude of financial problems, which negatively affected its ability to provide basic services. The failure of the Makana municipality to deliver services, particularly water and sanitation, was very serious. Makana also failed to address sewage spillages and resorted to sporadic refuse collection. The road infrastructure crumbled, the electricity supply became erratic, and absence the sustained delivery of basic services like sewage disposal, refuse removal, water and electricity, the immediate environment of the community suffered due to pollution. One of the underlying causes of the deterioration of governance in Makana appears to have been the failure of the municipality to uphold ethical and legal obligations. The municipality was mired in numerous allegations of corruption, nepotism, and financial mismanagement. The Auditor General investigated the municipality and reported that fruitless and wasteful expenditure raked up to 9.9 million rands, while unauthorized expenditure raked up to 254 million rand in the 2016 financial year. This was very serious. Financial mismanagement also manifested with an unfunded and therefore unlawful budget of 32 million rand for the 2017-2018 financial year. At the hearing of the Unemployed People's Movement case, which is known as the Makana case, the evidence before the court showed that the municipality had poor governance and it was unable to collect its revenue. As such, it was owed an irrecoverable debt amounting to 145 million rand. As a result of these violations of municipal financial management law, Makana failed to meet its obligations on many fronts. It became unable and at times even unwilling to utilize its powers and resources in the best interest of the Makanda community. It breached every object of developmental local government as stipulated in Section 152 of the Constitution. This situation was untenable. It now necessitated a provincial intervention. The Makana situation eventually led to 2 provincial interventions. The first intervention was in October 2014, followed by another in February 2015. The first provincial intervention led to the appointment of an administrator and the development and adoption of a financial recovery plan for the municipality. This plan identified several key strategies to reduce expenditure, increase revenue, and ensure that proper administrative and governance arrangements were in place to address the key financial and service delivery challenges. It was estimated that 800 million was required to upgrade services. The plan specified that should the municipality fail to implement the recovery plan, provincial government could consider alternative measures, including the dissolution of the municipal council. This did not help the municipality. By the end of the first intervention, there was little improvement. The recovery plan had not been implemented, and when a second intervention was instituted, it also did not yield any results. Then in September 2015, the High Court in Grahamstown issued a structural interdict directing Makana to develop and operate the municipal waste disposal site, among other interventions. The report detailed a number of things that could have been done and things that went wrong, but none of them were implemented. As such, the court intervened and ordered the provincial government to intervene. I'm not going to repeat the facts, or rather to trace the facts in the Emalahleni case, but I'll just simply summarize and say that what happened in this case is exactly what was in Makana. There was a problem with water, there was a problem with electricity. Eskom was switching off power because the municipality was not paying. So Mr. Kutsie, one of the lawyers in Mpumalanga, then approached the High Court, asking the High Court to order the Premier of the province to intervene. The court granted him his order. For both municipalities, as I conclude, these interventions have not brought any meaningful change. In fact, the municipalities could be worse than they were before. I'm now going to end here and hand over to Prof. Plessis. Over to you.
Thank you very much. Johandri, next slide, please.
Prof, before you start, just to alert you, you will have 6 minutes left.
Thank you very much, Clive. Right, so I think all of us present here knows that South Africa's got an established cooperative government system in the sense that it's being provided for in the Constitution, and we need to understand judicially ordered provincial interventions against this background. We've got the 3 spheres and the 3 branches of government, but the courts are not to govern, especially when it gets to municipal service delivery and the conditions that Johandri and Felix so eloquently elaborated on. But the Makana and Emalahleni cases illuminated also the desirability, sustainability, and potential risks when it gets to judicially ordered mandatory provincial interventions. In other words, those interventions that provinces did not by their own doing decide to undertake. Next slide, please, Johandri. So in terms of the desirability of court interventions, I think we should say that it's a matter of upholding the Constitution in terms of the rights of people, but also the attendant duties of the state. So the courts have been doing so for many years. If you see Moseneki's name there on the screen, he's also written a quite elaborate piece on this. But the severity of the socioeconomic, financial, and environmental impacts when a municipality is in fact in a financial crisis and cannot provide basic services or meet its financial commitments is well documented. And it's prudent that such crises and impacts be avoided whenever possible. When they occur, the Constitution must be followed, and the provinces must intervene according to the constitutionally prescribed process, and Felix described that. But they should do so in a manner that will bring about meaningful positive change. And when a province refrains from doing that, like we have seen in the Makana case, or they refuse for a political or whatever other reason, then they have no choice. The courts have no choice but to decide the matter and order the intervention. The next slide, please, Johandri. So in terms of the sustainability of judicially ordered interventions, we know that litigation is costly, time-consuming,
and inevitably damages relationships. So for us, it would be naive to support a remedial system for failing local government that depends on court orders. In addition, municipalities enjoy exclusive powers on matters listed in Chapter 7 of the Constitution, and as such, the legislative powers of local government are protected from both national and provincial intrusion through constraints on what Parliament and provincial legislatures can do in functional areas reserved for local government. So while this preserves the autonomy of municipalities, it potentially makes it impossible for provincial and national governments to avert deterioration of the provision of municipal services until a time that the situation is so bad, like in Makana, that the only available avenue is the mandatory provincial intervention in terms of Section 139(5) of the Constitution. So arguably, this is our argument, intervention at this point may never reverse the damage. Timely intervention is necessary to prevent permanent harm to communities when local governance collapses because of a financial crisis. In the event of the politically driven or other unwillingness of provinces and national governments to intervene in a municipality, the communities affected have very few viable options to safeguard their interests, and probably the best under the circumstances would be an order of the High Court, which would then compel the provincial national authorities to intervene. While this is an available and viable remedy, it should be a matter, in our view, of last resort. It cannot be, in our view, deemed as sustainable. Instead, and this is what we would like to advance, consideration should be given to how best national and provincial governments can provide preventative support, oversee and build capacity at a much earlier stage to avoid the deterioration of municipalities to such a state of dysfunction that intervention must be invoked and judicial intervention becomes necessary. And we find support of our view also in the works of Chamberlain and Masiango in a recent article in the SA Law Journal. Next slide, please, Johandri. In terms of the potential risks, we see that a distinction should be drawn between the potential risks of provincial intervention in local government and the risks that go with judicially ordered mandatory intervention. So when a court of law makes a ruling that triggers concerns about the separation of powers, there's always a chance of potential judicial overreach. And this occurs when a court acts beyond its jurisdiction and interferes in areas that fall within the mandate and governing domain of the executive or the legislature. Thus, there is a need for judicial restraint. Another potential risk is the lack of democratic legitimacy and capacity deficits when a judge rules in cases with potentially far-reaching consequences. And this is part and parcel of the conflicting demands placed by the Constitution and its democratic commands on the court. So when faced with such situations, courts may defer to the executive or operate as a corrective to policy that do not accord with the people's rights. Judicial hesitation to order an intervention on the pretext of possible harm that could be suffered by a municipality or the municipal councillors runs the risk of deepening the harm done to the community by the failures of the municipality. And in this similar but slightly different context, the Constitutional Court in the Mulema municipality case a few years ago said that it needs to be stressed that the potential prejudice and urgency lie not in the harm suffered by the municipality or the municipal councillors, but in the continued disruption of basic essential services to the people and communities the municipality is supposed to serve. The court also said that it's clear that where access to water, sanitation, electricity, and fire and emergency services once existed, but is then taken away due to a dispute within or relating to the management of a municipality, there will again be a violation of the fundamental rights of inhabitants. So the real risk related with courts ordering of mandatory provincial intervention lies in what it suggests about the legal framework pertaining to municipal support, mandatory interventions in local government, and the responsibility and accountability of provincial authorities. Last slide, please, Johandri. So South African law, we know, provides several options for recourse in the event of failure of local government. That's widespread, and Johandri explained that. These range from authorized service delivery protests, civil court action for damages, the recouping of wasted funds, and so on. You see the rest on the screen. It also includes the taking over by civic organizations of municipal services, as was done in Petling Rivier, as much as we might want to oppose that outcome. But we see that national and provincial governments also dedicate substantial resources to support municipalities in the form of advice, training, financial injections, such as grants and deployment of human resources. So that's also on the cards. But our question really then is, and we hope to generate some discussion about this, is whether or not judicially ordered provincial interventions might not be too little too late. And in the context of this conference, we think it's prudent that we also remember that when municipal service delivery failed, we fail both Section 24 and Section 25 and often also 26 of the Constitution. And these are incredibly important for the maintenance of environmental justice at the most local of governance, local level of governance in South Africa, but also there where people live and work. Thank you.
Thank you very much to Johandri, Felix, and Prof. Anél. Now we'll move on to the second set of session for Prof. Anél again. You're up here on deck again, Prof. That was a very erudite and revealing discussion on such a topical issue in South Africa. We all managed by municipalities, and we all know the problems that we've gone through with them. And as the case law is showing, that there's definitely scope for further intervention outside of the judicial interventions, or at least an earlier intervention by the judiciary. Without further ado, Prof. Anél, you can take over. Prof. Anél, next presentation is when the legal objectives of sound financial management, environmental justice, and spatial transformation collide, the case of South African cities. Prof. Anél, you can take over. Angela will just monitor you in terms of time, and she'll notify you hopefully in the last 5 minutes before your time is up. Please take over, Prof.
Clive, can you just confirm that you can see my screen?
Yes, I can see your screen. Maybe you want to put it on present mode.
Just a second here. I've got
Should be right at
here.
the...
Apologies.
No, it's fine. Is your screen freezing on? Sorry, Prof, you're muted. Prof, you're muted. Do you can you please? Okay, please go ahead.
So apologies, everyone. I'm going to stop my video. I seem to be having a problem here. Clive, just give me a second. I've got a technical issue here.
No, that's fine.
Right, so are we still on the first slide and everybody can hear me well?
We can see you, Prof. It's on present mode. Please take over. Thank you, Prof.
Excellent. Thanks very much, Clive, and good morning, everyone. So in the interest of time, I already wasted a few minutes. This presentation concerns, in a nutshell, the tension between Municipal Finance Management Act and the pursuit of spatial justice. And it's a presentation that's based on a research paper, as you will just, as I will explain in a short while. But I would like to start with a statement this morning that, and it's been made by Brad Jessup a few years ago, that environmental justice has always been about space. And I think this rings true to many of us in South Africa. We also know that spatial injustice flourishes particularly well in urban contexts. And against this background, we see two scholarly discourses going on globally at the moment. The first is the role of cities in the advancement of global sustainability governance and Earth systems governance, but also the role of cities in the advancement of the principles of international and domestic environmental law. And there's been a flurry of new publications in this field. But then secondly, also we see that environmental justice depends on spatial justice, especially in our cities. And the reasons for this range from proximity to pollution, environmental health risk, disaster-prone areas, to issues such as fair access to and benefit from natural resource-dependent services, such as water services. We also face place-based dangers in a geographical sense of environmental risk. We sit with space-dependent resolutions for the mounting waste that we've got in our country. Cities are known to be spaces of vulnerability and privilege in terms of climate change impacts. We also see that in South Africa. And then also spatial issues affect urban ecosystem services protection. And we've got many examples of this, KwaZulu-Natal, Western Cape. So if necessary, I can elaborate on that a bit later. So the relevance of spatial injustice in the context of this conference need not be elaborated on too much. We've got this notorious, we've made the cover page of Time magazine 3 years ago. And on the right-hand side, you see people flocking to the ever-expanding Sandton City in Johannesburg. So against this context, I want to bring in the project that the South African Research Chair in Cities, Law and Environmental Sustainability worked on last year. We were approached by the SA Cities Network, and more specifically, the Built Environment Integration Task Team, which is a division within SACN, to help them with the problem. And this task team comprises of all of the spatial planners or the urban planners that sit in the metropolitan municipalities in our country. And their problem was framed as follows. Municipal finance management law is thwarting spatial transformation and therefore spatial justice in South African cities. So to put it differently, they came to us and said, we can't help towards spatial transformation. We can't actually do our jobs well because of municipal finance management law. So essentially, they asked us to explore what they've experienced as conflict between the MFMA and SPLUMA, which is, of course, our framework law for spatial planning in the country. So this project for us was very relevant. We sit with apartheid that left very deep scars on occupation of and access to urban space. We know that spatial justice for us concerns social and physical space, and that the discriminatory forces, historical and ongoing, include, or behind spatial justice include class and race and gender, as well as age. And Jeannie van Wyk and others have also written in the past that spatial injustice impacts spatial transformation, but it also puts democracy, environmental justice, and other development outcomes at risk. So here we are in 2021, and I think all of us know that spatial transformation in our cities remains just way too slow, as it requires an overhaul of exclusion. But in the face of many other pressures, we sit with deteriorating urban infrastructure, we sit with the vulnerability of our socio-ecological systems, not only in our systems, but also in the hinterlands on which it depends. We sit with a weak local economy and investor confidence, and COVID did not help us in this regard. And we've got political turmoil and civil unrest in local government of the kind that Professor Humphrey so eloquently discussed last night. But we know that in our country and also in other countries historically, law served as at least a pathway to spatial justice. And we've seen extensive local government and spatial planning law reform in our country in the past couple of years. So the methodology we adopted in response to this project or problem that we've been confronted with was to undertake a legislative analysis of the MFMA and the SPLUMA. And we complemented that with a qualitative analysis of stakeholder inputs. We've had individual semi-structured discussions with planners as well as with municipal finance management officials. And we've had with the same group of people closed group discussions, webinar style. It was also nice for me to see recently how this method it was also underscored as the preferred method for doing research on spatial justice and spatial planning issues. It was an article by Patterson et al. It's not Sandy, it's another Patterson, published recently in the journal Urban Sustainability. So what we've done, just to get back to the qualitative analysis, we really wanted to deal with problem diagnosis and understand the reasons for the frustration experienced by the city planners, and to hear the actual challenges and also their suggestions for change. When we had the webinars, the closed group meetings, we had confirmation of the problem diagnosis, but they also raised additional challenges and additional suggestions for change. So what did we find? The legislative analysis, surprise, surprise, showed legal complexity and legal fragmentation. We know that this is in environmental and spatial planning law a huge problem. So the planners really operate in a legal framework that is as much a non-linear multi-piece puzzle as the city environment it applies to. So SPLUMA, we found when we looked at the letter of SPLUMA, if you can put it like that, it's been in operation since 2015. So it's 12 years younger also than the MFMA. It's the chief national legislation for spatial transformation. It's got 5 beautiful principles for decision making. It establishes various instruments for spatial governance, including the STFs, LUMs, bylaws, and others. And its objects are to secure sound and sustainable, a uniform and effective and comprehensive system for spatial planning and land use, and to promote social and economic inclusion and development principles and norms and standards. And it's all about sustainable use of land, cooperative government, redress, and equity. But the MFMA, on the other hand, is the chief national legislation for municipal finance management. It's providing for transparency, accountability, appropriate lines of responsibility. It's all about processes, instruments for revenue management, asset management, supply chain management, and all of those things that generally does not make a public law scholar that excited. But its objects, and I need to emphasize this, are to secure sound and sustainable management of fiscal and financial affairs of municipalities, modernizing the financial management system and accounting, and the object is also to maximize service delivery capacity. That's at least what the Act is saying. So then the key findings continue in the sense that we had to conclude that the MFMA is about fixed procedural requirements, specific auditable requirements, rules, and enforceable provisions, and it's inward facing in the sense that it's about improved performance and financial capacity within a municipality. But on the other hand, SPLUMA requires visionary application. It's a far more creative act. It translates into aspirational principles, and it seeks the adoption of instruments at the discretion of municipalities, at least the content of those instruments. And for that reason, it can be regarded as an outward-facing act. It's all about the improvement of the well-being, the environment, and the space of people in South Africa. The quantitative study, the discussions that we had, revealed that planners have difficulty expressing their exact frustrations with the MFMA, and there's also no consensus. There's a scale of unhappiness with the MFMA, if I can put it like that. The municipal spatial transformation projects that they refer to in the examples ranged from small neighborhood renewal projects to large infrastructure expansion projects, but all in the name of spatial transitions and spatial justice. And these projects, however small or large, triggered supply chain management and procurement processes in the municipality. And the planners said that the MFMA allows so limited, if any, space for deviation in the interest of spatial transformation as the chief objective of SPLUMA. And here you see some of the quotes from the people that we talked to. One of the planners said that engaging community members such as artists and community-based organizations in the projects of a city is key for spatial transformation, but the MFMA makes this difficult. One of the financial guys said here to the right, the planning departments in municipalities are generally not good at providing estimates of expenditure, and that is a problem for them. And here in the middle, hello?
There's 5 minutes.
Thank you. Spatial justice of the kind envisioned in the Act cannot be translated into monetary terms or financial value. It rather speaks to social gain and lasting positive impact on human health and well-being. So after this, we went back to the theory and the literature to read about what to do with the perceived or real conflict of law. And we found that at least 5 groups of people have worked on issues like this in the past, none of them from South Africa, really. Pokwana and Kyobe gave us 3 understandings of the lack of or the misalignment of legislation. They say it can be a lack of coherence, it can be a lack of harmonization, it can be a lack of interoperability, and these are being impacted on by political and legal factors, psychological and technical factors, as well as a lack of sometimes standards. And this leads to non-compliance. Santasosu and Malarba, they said that we should ask 3 questions when when we get to the interoperability of laws. Are two or more laws part of the same legal system? Do they adopt the same language? This is figurative language, of course. Do two or more laws adopt the same language, but they are part of different legal systems, planning, financial, or are two or more laws part of different legal systems and they adopt different languages? Then we've got Buitelaar and Galle. They remind us that individual pieces of legislation are always more static and schematic than the actual social phenomena they presume to typify. And I think we can associate with this. So for them, there are 5 types of interaction between planning law and other law, from most to least congruent, complementary on the top, and competing at the bottom. And then Buitelaar and Surrey from the Netherlands indicate in their research that different laws value different things. And in the Dutch legal system on planning, for example, there's also this tension between legal certainty and legal flexibility, and one should make peace with it. Boertman, if we think about the legal, the law reform process that we underwent in South Africa, reminds us that meaningful law reform must be sensitive to the concept of law as an organic entity with a past, present, and future. And this might raise questions in relation to the MFMA or not. So it's a view of law reform which espouses balance between stasis, what is fixed, and change for its own sake, in the hope that law reform can be meaningful. So my concluding observations, spatial justice depends on legal intervention, and spatial injustice may cause or deepen environmental injustice of millions. We live in an urban age. This is a problem that's only going to intensify, but we don't need more law. And those who have been involved in the IUCN conferences of a couple of years ago would remember the one person who was always calling for more law, but that's not what I think we need. The starting point is problem diagnosis. And I think there might be a romanticization of the commensurability of the legal framework applicable to local government. And it is a complex legal framework. There is insufficient legislative alignment, but we don't understand this in full. And there might be absent harmonization of law, but the problem can also be something else. It can be a lack of alignment between the operations and planning of line functionaries in the 3 spheres of government. There can be a too narrow interpretation of the law or a provision, especially in the MFMA. There can be inadequate or absent communication between communities, businesses, local government officials, those responsible for the spatial planning and financial management portfolios in municipalities. There could be a general problem with the design, implementation, and enforcement of the MFMA that also happens to affect spatial transformation objectives, but the same could also be true for SPLUMA, and where design problems is just intensified by provisions of the MFMA. There can also be an overestimation of the transformative power of spatial planning, where it may be easy to regulate to keep undesirable things from happening, but much harder to make desirable things happen. And I think that is part of the problem with SPLUMA. There could be an underestimation of the fact that the urban built environment is a combination of public and private investment choices over time, and that municipal investment is a rather small portion of the total investment towards spatial development in a city. There's a lack of money. We don't know the causes always. There could be an absence or insufficient goal-oriented cooperative government within municipalities itself. Lastly, there could be limited use of municipal governance tools that may be employed to achieve spatial transformation objectives, such as property rights and utility pricing. And I know that this is a sensitive issue. And then my very last point is that there might also be a hesitancy, myself included, to admit that sustainable use of land depends on economic potential, and that spatial planning in combination with environmental considerations may in some instances create barriers to what might make economic sense. And I'm going to stop there. Thank you very much for the opportunity.
Thank you very much, Professor Anél. That was a really insightful discussion on the tensions involved in trying to sustainably manage financial resources in municipalities as part of the pursuit of environmental justice through spatial planning. We have quite a few questions and about 14 minutes or so to address them. I think I will start with the questions for the first paper and then move on to the questions for the last paper. So the first question is from Sue George, and I also do invite anyone else who has questions to raise their hands. But Sue wanted to know, are you suggesting that the whole cooperative governance notion undermines the ability of an entity to be held accountable? And do you think that there's a more efficient and expedient way for than waiting for a high court solution? So she asked that. Peter was asking if a structural interdict may be helpful to hold municipalities accountable. So we'll start with those two questions and then I can continue with the rest.
Thank you, Angela. I see that Sue says at the end that her question has been addressed towards the end of the presentation. So I'm going to move on to Peter's. Would a structural interdict help? I think it is a possibility, Peter, and I would also like to hear Felix's view on this. The dilemma with a structural interdict is that the courts should follow up, and the courts do not have the capacity to do so. So again, it is on paper a beautiful remedy, but the judicial capacity in as far as we sit with overloaded court rolls, even without any municipal cases, is part of the challenge with the structural interdict. Felix, you might also have a view on this.
Thank you, Prof. And yes, I have a little bit of a view. My issue with the structural interdicts or other types of interdicts is that they involve the judiciary in matters of failing governance. And whereas it could provide some temporary relief to residents who might feel that something is being done, but at the end of the day, usually the collapse of local government is a result of a political process. I would describe it as a political problem that cannot be solved from the bench. A judge can do just as much, but there are so many factors that are intertwined in those issues. And most of the time, these municipalities collapse because of squabbles within the political elite. At times, judges have actually brought solutions for communities, although there are doubts about such solutions, such as in the Northwest province, where the court ordered the municipality to hand over the waterworks to the Residents Association. And within 3 days, the residents had water when the municipality had been failing to provide them with water for some time. So I would say that it is both good. The structural interdicts are both good and both bad, but I think we need more sustainable solutions that do not lie more in the bench, but in the political process that drives governance. Thank you, Prof.
Okay, we have a question from Professor Michael Kidd about the intervention, asking if the overall model of local government or municipal intervention is broken, and in relation to water issues, if there's scope in terms of the National Water Act for the department to assist municipalities with those functions. And then we have a question from Natalie about if there is a legal avenue for residents or ratepayers associations to intervene where there's an extreme situation of municipalities not fulfilling their functions.
Johandri, I would also like for you to respond. Thank you, Angela.
Johandri, perhaps you can respond.
I will start with Professor Kidd's question. I don't know about the Water Act, but I do know that the Constitution in section 39(7) makes provision for the national executive to act in place of a province where the province fails, where the province do not want to intervene or cannot intervene, that the national executive can act in place of the provincial executive. But with regards to the model of interventions, I have observed that often interventions happen too late and then they end too soon. So it's not really a sustainable path to repair the problems that's already in a municipality. And also interventions often cause a power struggle between the council and where a municipal council has been dissolved, where administrator has been appointed, between the council, the administrator, and the intervening body, whether it is the national executive or the provincial executive. And perhaps it's necessary to revisit the ideology of cooperative governance as opposed to a prevailing sentiment within governance that everyone is king of their own castle, that perhaps if the whole notion of cooperative governance is revisited and re-emphasized in government, that the spheres are supposed to support each other and not just when there's an intervention that has to be done. So that is on Prof. Michael Kidd's question. And then on Natalie's question for the legal avenue for local residents, a structural interdict or interdict of some sort may be one of the options that one can look at, but also instead of going to the judiciary, maybe to enter into negotiations with the municipality through private-public partnerships, or to just plainly go into negotiations through mediating or alternative dispute resolution. It hasn't been used that often yet to my knowledge, but it might be one of the options worth considering.
Thank you, Johandri. We also have Karen, who would like to ask some questions over voice.
Thank you very much, Angela. Can you guys hear me?
Yes.
Excellent. Well, I first want to point out the correction that the Constitution does not guarantee everyone the right to a safe and healthy environment. People often make that mistake. The Constitution guarantees a right to an environment not harmful to your health and well-being. Unfortunately, the word safe and healthy has been taken up into the Municipal Structures and Municipal Systems Act, and that is a contradiction of the Constitution, because it's in the space between safe and healthy and not harmful to the environment that we actually have the opportunity to do things such as dispose waste and discharge treated effluent into rivers. And one has to be very careful not to make that mistake, to think that you have the right to a safe and healthy environment. If that was the case, government was supposed to come and clean my house, and they won't have the money for that. And that's the first point I wanted to raise. And the second point I wanted to raise is, I don't think we're sitting with a constitutional problem. What we're sitting with is most of our environmental legislation created criminal liability for pollution and did not create alternative mechanisms for intervention if there is a problem or if there is pollution. And there are many other alternative interventions when something happens that can damage the environment. So I'm always recommending that when we revise NEMA or when we revise the National Water Act, that we should create alternative mechanisms for non-compliance by local government that does not impose a criminal liability, because that creates the constitutional conundrum of you can not take legal action against local government where they do not comply. So my recommendation is, if any one of you are involved in revising the NEMA or revising the National Water Act, to make it a very strong point to ensure that there are alternative compliance mechanisms built in that is not just a command and control criminal liability approach. Then the second or third point I wanted to raise is, now you see why I couldn't type it all out. The third point I wanted to raise is that one has to remember that we moved from a system where municipalities only catered for a small portion of the population in their service delivery to a system where we now have to all of a sudden do a large portion of the population in their service delivery. And much of our infrastructure that has to do this service delivery simply, number one, does not have the capacity. And number two, our Dashboard Sewage Works was built in 1910. Are over 100 years old, 50 years old, 80 years old. And in Europe, they had the opportunity in the 1950s to rebuild all their sewage and water management infrastructure because everything was bombed to smithereens. Whereas we did not have the same opportunity, and our works are mostly older and built before the 1940s. So we sit with aging infrastructure that are undercapacitated, and that means that we now have to make use of alternative mechanisms. There will not be compliance if this infrastructure is not there. And in the old South Africa, we had this thing called the Regional Services Council, which made funding available on a regional basis, not political. It was totally an administrative body. And the Regional Services Council created a lot of quite well-built infrastructure. Unfortunately, some is like state-of-the-art, mega million rand systems in very rural areas where there's simply not the capacity to operate those state-of-the-art systems, and one has to guard against that. And then in Prof. Anél's presentation, I heard her speak a lot about the Municipal Finance Management Act, but I think there's another one which we might overlook, and that's the Division of Revenue Act. Now, if one can have a mechanism by means of which you can say, well, this municipality, they're really trying, they have the capacity, but they simply lack the extremely expensive the funds to build sewage treatment infrastructure, which runs into millions. Let us use the Division of Revenue Act to assist those municipalities that maybe perform well on a green drop, blue drop assessment, which is a part of a civil-based instrument as an alternative and compliance improvement mechanism. So this is a very complex issue, and I want to thank the presenters for highlighting a number of aspects in that regard. But I think one should really apply our minds in thinking, how can we improve compliance by local government from a different perspective than merely command and control, and use the fiscal instruments that we have in legislation to assist them to achieve better compliance.
Thank you, Karen. We have about 2 minutes to answer that question before we need to move to the book discussion. So I'll give over to the presenters.
Karen, thank you very much. I'm so grateful for your presence also. You've got a lot of understanding also from the scientific background. I always listen to you on the radio nowadays that I can't see you in person at conferences anymore. I can but only agree. And Sue earlier alluded to the fact that, okay, so what do we do? And Mike, by asking whether or not we've seen a collapse of the local government system, is hinting at the same problem. And you might be aware of this transition to the district development model. And I saw in the chat before I was rudely thrown off Zoom that someone also mentioned this movement to the district model system, which might be in some way a transition back, Karen, to that old service, district service model that we had previous, but I'm not too sure how politically clear that is going to be, in the sense that I have my suspicions about that just becoming another layer of government, unless the politics is being removed. And we rethink also the position and place of provinces, because you mentioned DORA, but provinces, we should not forget, is huge consumptive. They are consuming a lot of the national fiscus resources. So I think we need perhaps a rethinking of the entire government system, not only local government. It's not only the local government model, but obviously, I mean, that is, we can't go back to the drawing. We will never succeed. And we sit with this protection of the autonomy of local government. That is an issue all over Africa. We see increased pressure on local government autonomy to protect people against national governments that just go bonkers. So the tensions are real and vast. It's not only pertaining to environmental service delivery, but there's other factors and issues at play, and democracy plays a huge role in that as well. And Tracy, I think last night also pointed to some of those important factors that we need to bear in mind.
Thank you. I don't see any questions from anyone else. I don't see anything in the chat, so I think that wraps up this session. I would like to just again thank the presenters for really doing a good job at facilitating discussion and critical thinking on these complex issues in local government. And thank you as well to everyone who asked questions. Yeah, I assume we'll all then pop off to the next session about the book that has been announced. Thank you, everyone.
Over to you, Prof. Anél.
Thank you very much, John. Ladies and gentlemen, I'm really sorry that you are confronted with my face so much this morning, but I've got the pleasure of introducing you to two new publications. So it's a, so to speak, virtual book launch. It's not very formal. I'm going to do a screen share here. So the first that I would like to introduce you to this morning is a book published by Juta. It was edited by myself, but that is besides the point, because as you will soon see, an incredible number of people, many of them involved in this conference, have contributed to that book. But before I get to the book, I just also from my side want to thank Juta. They've been our main conference sponsor for this year, and they've really enabled us to do a few things, including the prizes that were handed out during the past 2 days student conference. And then also I can just indicate that all of the titles that you've just seen in the video that John played are available at a 15% discount for conference delegates. There is a form to be filled that will be shared by email with everyone participating in the conference. So if you've seen a title that you really want, now is the time to buy it. So the book I want to introduce you to first is Environmental Law and Local Government in South Africa. It was published a few months ago. Obviously, the publisher is Juta. Myself was the editor, and we've had close to 40 contributing authors. And I think I can just here make the point that it's not only been academics. We've had quite a few people from practice, environmental law practice, and then also people in government who have contributed chapters to this book. So I think in that sense, it really brings together the knowledge and skills and understanding of a range of different experts. And often books of this kind tend to be very theoretical, but I hope that we've managed to achieve a mix of providing the legal framework and stating the law in combination with examples that can be useful also for people that need to implement local government, the environmental laws that are applicable. The scope of the book, I will run you through the different chapters just now. You will see that it includes a range of broader issues, but also sector-specific issues ranging from water to biodiversity to green building. It's a very thick book. Unfortunately, I don't have it with me now, but it's approximately this thick. It's a real door stopper. So if you can't use it for anything else, that might be an option. The intended audience is broad. It can definitely be used as a textbook, although the poor students that have to work through such a thick volume in a year or even in 6 months, that would be tough. But I do think it's a reference work that students could definitely use, definitely people in local government, but also researchers working on comparative studies that would like to compare the environmental law framework as applicable to subnational government in South Africa with other countries, especially, I think, developing countries. Access, it's a physical book. It's thick, as I've said, and I'm always cautious that books of that kind might eventually fall apart if you use it often, but it's also an ebook, so it's available in both formats. So I'm going to run you through the 27 chapters. So there's an introduction by myself and Professor Johandri. And then we unpack, and this is not done in any other environmental law book or local government book for that matter in South Africa, the key elements for municipal action in relation to sustainability. We've put quite a lot of thinking into this several years ago. The one thing I forgot to mention, this is the second edition of the book. The first was published in 2015, so this is the second edition. And we've developed initially the key elements for the first edition and just refined the examples this time around. Chapter 3, we deal with the instruments for local environmental governance. This chapter is authored by Johan, myself, and Wilhelmine. For those of you who don't know, they are married. And I can just imagine that they've worked on this together in their study. Chapter 4 deals with municipal
Anél, are you there?
Do we have the slides? Then we can continue.
No, I do not have the slides of this. Perhaps we just give Anél a moment to log on again.
We must apologize. Potchefstroom is having electricity challenges this morning, so they tend to cut us off from time to time. Thank you, John. The other Plessis will try and present.
Lamine, you're mute.
Okay, thank you. Let me just see. Can you see the slide?
Yes, we can. Thank you.
Okay, so let me continue. Chapter 5 then was dealt with Tracy that you've seen yesterday evening, and she wrote on local economic development and the pursuit of the green economy. Loretta and Oliver worked on the environmental rights that's protected in the Constitution, Chapter 6, and that might deal with the issues that you have addressed, Loretta, Tracy yesterday evening, and that Karen mentioned. Chapter 7 deals with the regulation, mitigation of environmental pollution by local government. Sue Mostel, that's working at Cape Town Municipality, and Louis Kotze was responsible for this. Warren Friedman wrote in Chapter 8 on the conservation and sustainable use of natural resources and the notion of public trusteeship. Chapter 9, Paul Snyman and Trafford Patterson, both EMIs and working, the one is EMI, the other one is working with compliance, wrote on environmental law compliance and enforcement. Chapter 10 deals with municipal service delivery and the environment. Gerrit van der Walt, who is a professor in public management, worked on it initially, and Oliver then updated it. Chapter 11 works with cooperative government, intergovernmental division of environmental powers and functions, written by Nick Olivier and Francette Gous. Chapter 12 is dealt with by practitioners on air quality management, and that would be Chris Engelbrecht and Gerrit Cornelius. Chapter 6 deals with solid waste management. Reese Alberts and Simone van Rooyen, also both of them worked at the former Center for Environmental Management at the Northwest University. Chapter 14 deals with water services provision and protection of water services. And as you can see, that is quite a complex issue, as it was written by several authors. Mariette Swart initially worked for Water Affairs at some time, and Nigel Theodore Adams, and was then updated by Hugo van der Berg and Shirley Young. And they also worked with the chair in mining law at UCT at some stage. Then environmental health, something that we usually forget about sometimes in environmental matters, by Annette May and Mike Achenbach. Annette is from University of Western Cape, and Mike is worked with municipal services in this regard. Then chapter 14 deals
Wilhelmine, I'm back. You can proceed if you like.
Yeah, please go on.
I'm so sorry, everyone. Zoom is not kind to me. It's not a connectivity issue. Zoom just throws me out. Apologies about that. Wilhelmine, if you could just stop screen sharing, and then I'll share from my side. There we go. Thank you very much, Wilhelmine. It's most kind of you. Perhaps just on chapter 15, I can mention that even though this is such an important issue, we've got extremely little scholarship on environmental health in South Africa. I think the complexity also around the governance arrangements is just too difficult, and it's also changing quite often with the sending of functions to local government districts, sometimes to provinces and back. So it is quite an issue, and we are lucky to have Annette May and Mike Achenbach, who Mike Achenbach has worked in this area in local government for many, many years. So I was very grateful for his him joining us, especially on the second edition. Chapter 16, Land Use Management and Planning, again, François Retief and Berg, and they were joined this time by Jaco Vivier, who also historically worked as a planner. Tienus Meyer, Soil Conservation and Land Management, which we also don't often think of as a matter extremely important for local government. It concerns agricultural issues, but also matters around property. And then chapter 18, authored by Tienus again and Claudine Ruiz, they're also from the Northwest University, on hazardous substances management and control, which is similarly quite an important and very risky sector to be managed as part of the environmental health function, but it rendered it necessary also to have a separate chapter on that. Biodiversity, a very long and detailed chapter by Sandy Patterson, and you know him as a specialist in the field, and he's really gone at length to explain the relevance of local government and its involvement in biodiversity management and governance in South Africa. And related to that chapter is that of Marie de Tooy and Professor Sarah Sillier, also from Northwest, on urban ecology, which is also a rising theme from a legal perspective. It's established otherwise, but a fresh new perspective on urban ecology and the intersection with local governance. 21, Marine and Coastal Management by Local Government, originally authored by Marie Paramon-Gurney, you'll remember her, but it was updated by Sue Knox-Mastel from the city of Cape Town. I don't know if Sue is still here, but I saw her earlier on in the participant list. Very important chapter, especially for our coastal cities, of which we've got many. Chapter 22, Heritage Resources Management, edited by Christa Rautenbach, David Hart from the city of Cape Town, and Maurits Naudier, also known for his work as a practitioner in cultural heritage management. 23, Disaster Risk Reduction and Climate Change Adaptation and Resilience, written by Professor Dewald van Niekerk, a chapter that is really demanding a book of its own, and considering the impacts that municipalities increasingly have to deal with in their planning strategically and spatially. Chapter 24, Energy, written by Professor Tobai Marambo and Wilhelmine. Also an important chapter with the transitions required at the moment, and also the energy and electricity problems we face across the country. 27, the last chapter is it's not a case study, but it's a view from within, processes for action on utilities and environmentally related projects for sustained and effective local environmental governance, written by Susan Knox-Mastel and Barry Kutsia. They've written this in their personal capacities, but they both work for the city of Cape Town. So you are welcome to ask questions about the book in the chat if you like, but I'm going to proceed to the next book. I'm very conscious that we are already exceeding the time. The second book is titled Teaching and Learning in Environmental Law, Pedagogy, Methodology, and Best Practice. It was published 2 months ago. It's an international volume edited by Amanda Kennedy, myself, Rob Fowler, Evan Haman, and Sherry Warnock. We are from all over the world. The contributing authors are mainly scholars, given the topic of the book and the theme that we've addressed. Its scope is wide-ranging. It ranges from how to approach undergrad environmental law teaching, why we need to have environmental law in the curriculum worldwide, to issues of postgraduate supervision. There's also a chapter or two on the use of technology and flipped classroom teaching, and also the difficulty of teaching in a field that is so much influenced by science. So really an interesting and worthwhile publication with an intended audience being all of those people involved in the teaching of environmental law and its development as a subject at university level. Access, it's again also a hard copy and e-book, so it's available in both formats. Table of contents, fortunately, it's shorter than environmental law and local government in South Africa. First chapter edited by authored by Rob Fowler, myself, and a few others, titled From Marginality to Mainstream, The Evolution of Teaching and Learning in Environmental Law. Linda Collins and Brandon D. Stewart authored the second chapter, Engendering Hope in Environmental Law Students, very relevant in the current context. Karen Bupnalitik authored chapter 3, Bringing the Heart into Environmental Law Teaching, with a very personal approach to that chapter. Esther van Wagner authored chapter 4, Placing Natural Resources Law, Preliminary Thoughts on Decolonizing Teaching and Learning about People, Places, and Law, very relevant for many countries, and South Africa included. Stewart Bell, chapter 5, Is Your Textbook Still Really Necessary? Got an interesting take on the ways in which we present our modules and the type of teaching materials that we use, considering the fast pace at which environmental law is changing and how quickly textbooks become outdated. Tracy Bach, Techniques for Enhancing the Lecture Format in Teaching Environmental Law. Ben Boer, chapter 7, Teaching and Learning Environmental Law Using Small Group Teaching Methodologies, something we all wish we could have, especially undergrad classes are often rather large and difficult to manage in smaller groups, but that is the ideal. Kerry Warnock, Enhancing Learning in Environmental Law Through Assessment Design. So that's a chapter focused on how we assess, do we over-assess, how to creatively assess. Evan Hamann and Jill Witkowski-Heaps, Environmental Law Clinics in Australia and the US, a comparison of design and operation. And then chapter 10, Game On, Game-Based Learning as an Innovative Tool for Teaching International Environmental Law. That was authored by Alexandre Lillo and Thomas Burelli. Chapter 11, Teaching International Environmental Law as a Story, Chris McGrath, a very interesting chapter that as well. Heather McLeod-Kilmurray, The Emergence of Specialist Postgraduate Coursework Programs in Environmental Law. So that chapter deals with how we are seeing master's programs starting to focus on climate change law, water law, waste law, etc. Also a very interesting perspective on how we probably can no longer deal with environmental law in a single subject. Enriching the postgraduate environmental law classroom, combining mixed cohorts and intensive mode teaching, reflecting on the fact that we sit with people in our classes from different backgrounds, scientifically speaking, but also geographically speaking, and how to deal with that. Chapter 14, Doctoral Research in Environmental Law, Rationale and Some Supervision Challenges, authored by Wilhelmina and myself. That was part 1. Part 2, we looked specifically at the student-supervisor relationship in the next chapter. Then 16, Of Density and Decline, Reflections on Environmental Law Teaching in the UK and on the co-production of environmental law scholarship, Stephen Vaughan. Never mind the platform, here's the Pedagogy, e-learning in environmental law, and we always make fun of this chapter. It was written pre-COVID. It's now more relevant than ever. And then chapter 18, Teaching Environmental Law in Thailand, by Shakrit and Rab. For those of you knowing them from the IUCN. So those are the chapters, and this book is also, and this is now me putting on a seller's hat, can buy this book at a discount of 30% when you use this voucher code KEN50 when you check out online buying the book from Edward Elgar on their website. But we will also distribute this information by email to everyone participating in this conference. And I thank you and apologies once again for the technical glitches. I appreciate your presence. Thank you, John. John, I don't know if perhaps we should take questions if anyone's got any.
Yes, Prof, I think we can take questions.
Otherwise, in the interest of time, if people want to email me, they're always welcome. I think most people here would know where to get me if there's no immediate questions. Otherwise, I just invite you to buy the books, and I wish to thank again the publishers and the author, the publishing houses, Juta and Edward Elgar, and also Frances Kubeme from Juta, who is here present today. She was the managing publisher from Juta's side on environmental law and local government in South Africa. Thank you very much, everyone. John, I don't know if you have an announcement perhaps related to the next session.
Thank you so much, Prof, and the chairs of the previous session. So at this point, looking at my program, I realized that the next session is at 12, which will be a panel discussion of the recent case law. I think we can safely say we should take a break, make a cup of coffee, snacks, and we will reconvene at 12.